Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. This is a strange case that involves a number of different issues. First, police misconduct. It's real, but it's also fairly rare. Then there's a phenomenon that nobody ever sees who threw the first punch. And there's something called confirmation bias. Once the narrative is set, it is very difficult to unring the bell. And then justice sometimes is dependent on making some noise. I'm going to try to weave all that together in this story of lawyers behaving badly, but maybe not really. I want to give a shout out to David Barrett, who is a good friend and a fellow lawyer from Jefferson City, Missouri, who called my attention to this story. And I greatly appreciate him doing so. And so, shout out to Dave Barrett, who also has a background in law enforcement. So, let's jump in. This is a story about some lawyers in Philadelphia who were representing a client who had a very rough ride on the judicial train. Now, the sort of hero in our story is a guy by the name of Termaine Hicks. He is a fellow who tried to do the right thing. It was almost 5 o'clock in the morning. He's walking down a street in Philadelphia, and what does he hear but a woman screaming? And so he goes to her aid, or attempts to go to her aid, and gets there just as her attempted rapist sees him and flees. He tries to help the woman. Police arrive at that very moment and conclude that he is the perpetrator and shoot him 3 times in the back. And see, this is what I mean about nobody sees who threw the first punch, because a lot of times people, when they come into a situation and they see something in front of them without knowing what went on before, they don't have context around what they see. When they see a man bending over a woman after that woman has been screaming repeatedly for a long time, their natural assumption is that he must be the reason she's screaming. And so confirmation bias then comes into building a case against that person. And unfortunately, in this case, it started with 3 shots to that gentleman's back. In spite of being shot 3 times in the back, Mr. Hicks recovers, only to be sent to prison for 19 years because the police decided that he was a guilty guy. And they were able to convince a jury, even though there was no DNA evidence, and even though he looked completely unlike the person that the woman who was being attacked said had attacked her. So, flash forward 19 years, and the Innocence Project gets involved and reverses his conviction on appeal, relying for the most part on DNA evidence and the lack of witness testimony that he did this. It was a big win for the Innocence Project and something that should be celebrated. Mr. Hicks' way of celebrating it was to find attorneys who would take on a case for his civil rights being violated. And that's what happened. Now, at issue in the civil rights case is the police department's defense. They claim that this man was indeed the person who attacked the woman in the alley. But the way they have chosen to dispute this is to suggest that he could not possibly have heard at 5:30 in the morning a woman screaming from 2 blocks away. And so the defense set out to prove that with an expert. And as you all know, an expert is a former drip under pressure expert, or it's somebody with more than 2 briefcases who comes in from out of town. And that's essentially what the police did. They brought in an audio expert to come in and do an audio test at roughly 5:30 in the morning in this area of Philadelphia where this occurred. But instead of using a woman's scream as the, I guess, the inciting incident in that case to do his audio testing, he used a police siren and the rip that comes when you turn on the police siren. And he calculated the decibel level that came out of the siren, and then he went 2 blocks away and he listened for it. And although he made a few mathematical errors, he concluded that basically nobody could have heard a scream from 2 blocks away in Philadelphia. Well, that didn't sit real well with the plaintiffs because they wondered if people couldn't hear it from 2 blocks away, how the cops got there, which I think is a fair question. So they decided to do a test, but they decided to make their test more realistic because, as you probably know, people tend to ignore in a big city a police siren in the middle of the night because, for the most part, you hear a lot of police sirens in big cities at night, and that's what happens. People tend to ignore them. But the thesis was it wouldn't be as easy to ignore a woman screaming. So they decided to do a scream test. They hired their own expert and they notified the defense that they were going to conduct this test so the defense could be there if they wanted to. And it turns out the defense did want to be there. And they hired the expert to do this test, and he played a recorded loop of a woman screaming. So close your eyes for a second and picture this. You are lying in your bed early in the morning, just remembering that really great dream you were having, and all of a sudden, you hear this. And then you hear it again. And then you hear it again and again and again over the course of a full hour. Now imagine that you are an operator of a daycare facility that opens a few minutes after this test starts. And now you've got kids who hear a woman screaming. That sounds a lot maybe like their mom screaming. Well, as you might imagine, the defense counsel made as much hay out of this as possible, and they notified the judge that this had happened. They told the people around the community who came out and started complaining about it that this was all the plaintiffs doing and that they were involved in a court case in front of Judge Murphy. And at that point, the cat was out of the bag. The community members started calling the chambers. And there is almost nothing worse than hearing from the judge's chambers that your test has caused great community upset and that the judge wants you to show cause why you should not be sanctioned. Boy, that is not a good thing. So that's essentially what the plaintiffs and the defense did. The defense argued they should be sanctioned, and the plaintiffs said, don't sanction us. That hurts our client. We may have done a stupid thing, but we did it for the right reasons. Now, the plaintiffs sent this really long letter to the judge explaining what happened and how it happened, and they pointed out that this really wouldn't have even been necessary but for the fact that the defense got this expert, and this expert didn't know what he was doing. At his deposition, Dr. Bergalt admitted that he could have used a recording of a woman screaming for his experiment, as he had done in the past, but that he did not hear. He expressly testified that he made the decision not to use a scream and was never told he could not do so. But despite all the identified flaws in his study design, methodology, and calculations, Dr. Bergalt nevertheless repeatedly reaffirmed his opinion that WL's scream would not be loud enough to be noticeable to plaintiff. Although plaintiff did, and still does, intend to move under Daubert to preclude Dr. Bergalt's testimony, we realized it would not be possible to wait until after receiving a ruling to conduct our own rebuttal study. Given the current case deadlines, plaintiff therefore proceeded with our own study to ensure we could effectively demonstrate that Dr. Bergalt's opinions are not only unreliable but scientifically false. So, at the end of the day, what they tell the court is simply this. They say, plaintiff's counsel did not appreciate the impact of the study on the community or the impact that it could have had on trauma victims. although in hindsight, we should have. And we undoubtedly should have taken additional measures to ensure that our coordination with the Philadelphia Police Department to authorize the study would include advanced notification to residents. Plaintiffs' counsel would be happy to respond to the community members who have reached out to the court and apologize or conduct any other measures that would aid the court or help ameliorate the impact on residents. So, the main issue that was the reason that plaintiffs took this step of saying, hey, we screwed up, we apologize, but don't use it against our client, is because the defense asked to have that study excluded and that evidence excluded in the case. And so it was up to the judge whether that was going to happen. So here is the court's order. And it starts off with a quote from the Pennsylvania Rules of Professional Conduct. A lawyer, as a member of the legal profession, is a public citizen having special responsibility for the quality of justice. We demand that lawyers zealously advocate for their clients. But lawyers must not lose sight of their other obligations. In this contentious civil rights litigation, there is the dispute about whether the plaintiff, Mr. Hicks, could have heard a rape victim screaming from 2 blocks away. So Mr. Hicks' lawyers devised a test, and with no warning to the people who live and work near Broad and Passyunk in South Philadelphia, the lawyers played a looped recording of a woman screaming at 122 decibels for an hour at 5:30 a.m. by a daycare center that was opening. Alarmed local citizens found out about this case from the lawyers present and understandably complained by email to our chambers. After we figured out what was happening, we ordered counsel for Mr. Hicks to show cause why they should not be sanctioned. Admirably, counsel admitted error, took responsibility, and urged us not to punish their client for their actions. Considering the circumstances, we conclude that Mr. Hicks' lawyers owe the local citizens an apology. The opinion below explains how we reached that decision and specifies the nature of the apology. I could go through all of this, and you'd certainly be able to find any of this if you wanted to on Pacer. The case is up here, 2:22-CV-977, and it's in the Eastern District of Pennsylvania. It's an 11-page order. But here's the TLDR. The lawyers are ordered to write letters to all of the people who were upset, all the people who conducted any of this, and they have to make some in-person visits to sort of calm some ruffled feathers, which is appropriate. The interesting thing about this is it was the expert who decided to use this tactic and to get a realistic model of what happened. It wasn't directed by the lawyers to do this. The lawyers were just there present with him while he was doing the test. So it wasn't like the lawyers were the ones who were playing the stuff at high volume. It was the expert. And although the lawyers are responsible for the expert, it doesn't look like anybody really thought this one through, which sort of makes me wonder how effective they're going to be when they're trying this case for Mr. Hicks, who, if indeed he was wrongfully convicted and he had nothing to do with what happened, I hope that he is appropriately rewarded for his patience and diligence in pursuit of justice. But this is the kind of thing that happens when lawyers lose sight of what they're doing. The quest for justice is not a win-at-all-costs quest. There are guardrails. There are places you cannot go. You can't ever have a client lie. You can't ever let a client lie under oath. You have to be judicious in how you refer to other counsel. Now, that doesn't necessarily mean you have to be judicious about other counsel in the privacy of your own home. You can probably call them a number of hyphenated words suggestive of the fact that they didn't perhaps have natural parentage. Be that as it may, you cannot absolutely do that in court. And unfortunately, there have been people who have been prone to doing that kind of thing. Not myself, but I know others who have, and it never ends well for the lawyer. The important takeaway from this case is that these lawyers were trying their best to get a good result under ideal circumstances to duplicate the conditions on the ground on the day that this terrible event happened. You have to remember, a young woman's life was shattered on that day, and Mr. Hicks' life was shattered on that day too. And the police, honestly, hopefully, thought they were just doing their job. Somebody needs to be held accountable because, it looks to me like perhaps it was possible that the police manufactured the narrative because they knew that they had shot the wrong person after they talked to the victim. So all of this comes together in a way that essentially boils down to the fact that every now and then you have to make some noise to get justice. And that's essentially what happened here. They made some noise to get justice. They got their wrists slapped, and they should have. And hopefully they get a good result for their client. That's the story. I hope you found it enjoyable. If you have an opportunity today, go out of your way, do something nice for someone. Mr. Hicks tried to do something nice for someone. He heard a woman in peril. He rushed to her aid. There are many, many people who would simply close the door to their car and drive on to another place. He didn't do that. He went to rescue somebody who was in peril. That's a pretty nice thing. You may not have that opportunity today. Maybe you just have the opportunity to hold the door for someone at the supermarket. Whatever you do, remember, just doing a kindness makes the world a better place, one person, one act at a time. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. You can email me at the address above. And most importantly, thank you so much for being here. Come on back down here tomorrow. Join me at the beach and we'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.